What opens as a routine hearing immediately establishes the tone: who's present, who matters legally, and who doesn't. The judge sets control early, clarifying roles and expectations. This calm beginning masks what's coming: a dispute rooted less in money and more in accountability, effort, and communication. It's the kind of setup that feels procedural, but it lays the groundwork for every conflict that follows, especially when temporary orders and employment expectations come into play.
Yes, sir.
Zakia Payne and Kimmy Jones need you to unmute and turn on your cameras.
Your Honor, the grandmother, Kimmy Jones, she's not a party to this case. She's just here to observe
Oh,
or watch the hearing, I guess.
okay. Okay, Ms. Jones, you can just stay on mute then if you're not a party.
We did a temporary order establishing the parent-child relationship on this case in August of this year. The temporary order addressed all the issues. It set support based on minimum wage and ordered Mr. Jones to participate in choices. I don't believe that he's found in employment through choices and is still working Uber and Lyft. And so we are requesting that the temporary order using minimum wage be made the final order today, along with the other terms that have already been set in the temporary order.
Okay, go and call the parties.
Okay. The state calls the father. Sir, will you state your name?
Joseph Jones.
The father confirms the temporary order, his participation in employment programs, and his reliance on gig work. He speaks confidently about future plans, but nothing is concrete yet. Commission-based jobs, possible interviews, and training still pending. The court listens carefully because hope doesn't pay child support. This moment matters because it frames whether effort alone is enough or whether results are what truly count when the court decides to lock in a final order.
And what are the names of the children on this case?
Zara Payne and Zara Payne and Zakai Payne.
Okay. And we did a temporary order on your case in August, correct?
Yes, ma'am.
And you were ordered into choices at that time, is that right?
Yes, ma'am. I chose choices.
Did you participate in the choices program?
Yes.
And are you still working on their program?
Yes, ma'am, I am.
Do you have any job leads or any interviews set up?
Yes, ma'am. I have a solar lead that's coming next week. So selling solar panels.
Okay, and that's an interview?
Yes, ma'am.
All right, and then since we were last here in court, you've still been doing Uber and Lyft driving?
Yes, ma'am.
Okay. Do you have any idea of what your income might be if you do get this job with solar panels?
No, ma'am. It's based off commission. So basically, I have to set the lead, and then after the lead goes through, everything will be set in stone from the sales.
Okay, and is this a job that you had choices help you find the interview for?
No, ma'am.
Okay. Have you been to any interviews that choices has helped you find?
No, ma'am. Choices hasn't allowed me to get interviews. Basically, they said I signed up for the CDL license program, and I'm just waiting to hear back from them on that.
When asked if the temporary order should become final, the father hesitates. He claims he can't fully comply because he lacks documents and information. On paper, he agrees to custody terms, support amounts, and insurance, but this hesitation signals deeper friction. It's not about the numbers, it's about cooperation. This moment introduces the recurring theme of the case: both parents saying they want to do the right thing, while blaming the other for making it harder.
Okay, so you're to start studying to get a CDL. Is that what you're doing with choices?
Yes, ma'am.
Okay. And are you wanting this temporary order to be made the final order today?
No, ma'am. I haven't received anything required in the temporary order, as in the kids' insurance cards or social security cards or things that was really stipulated in the order. That way I can do what was actually required of me to do in the beginning, as in the name request. And so, no, ma'am.
Okay. So are you still in agreement to be joint managing conservators with the mother
Yes, ma'am.
and to have a standard possession schedule?
Yes, ma'am.
Okay. And are you still in agreement with Ms. Payne carrying health insurance for the children through the government plan?
Yes, ma'am, that's fine.
Okay. And the order has you paying, let's see, has you paying medical support of $94 each month and child support of $266 each month. Are you still in agreement with those amounts?
Yes, ma'am, that's fine.
The father raises communication issues, claiming he reaches out but gets silence unless money is involved. He insists he's active in the children's lives and even exceeds the visitation schedule. The court presses him, separating emotion from facts. This segment is important because it shows how quickly child support cases stop being about finances and turn into battles over respect, trust, and who feels heard and who feels ignored.
And the court already ordered retroactive child support and to be paid that at $40 each month. You understand that?
Yes, ma'am, that's perfect.
Okay. Is there anything else you want the court to know about your case?
Yes, ma'am. Basically, non-compliance and communication issues. That is the main thing that's going on right now. How should I say? I opened the line of communication August 8th, just letting her know that I'm open to communication with her for the better segment of these kids. And that was no reply on that one. I understand she doesn't have to reply, but at the same time, it's more of a just being open to communication with that's going on regarding of these children. Um, then another one with the payments. I don't have a problem with the payments, but the only thing that she seems to care about is the payments. I have recordings of the payment, text messages, and all communication that's going on with that. And then, how should I say, more of I don't want to say the lack of non-trustworthy of words. Let me say that part. So it was September 21st.
Okay. Mr. Jones, have you not been able to see the children?
No, ma'am. I've been grabbing them more than the court order required me to.
Okay. How often are you having them with you?
Every weekend.
Okay. Okay. I'll pass the witness. The state calls the mother Miss Payne. Ma'am, will you state your name?
Yes, okay.
And Miss Payne, the temporary order that was done in August of this year, are you in agreement with that being made into a final order?
She agrees with most of the order but draws a firm line on safety. This isn't about money, she says. It's about her children coming back injured without explanation. Missed weekends, confusion, and fear replace earlier procedural calm. Her concern isn't hypothetical, it's personal. This moment matters because once safety is raised, the court's focus expands beyond payments into parenting judgment, communication duties, and responsibility during visitation.
No.
Okay, and do you not agree with the child support that's been ordered?
No, it's not about the child support. I don't have a problem with the child support.
Okay, the court already set standard possession schedule and joint managing conservatorship. Are you in agreement with that continuing?
Yes.
Okay, and so you're okay with the child support remaining at $266 each month?
Yes, that's fine. I'm just concerned about the safety for the temporary weekend schedule that we had.
For Mr. Jones having the children every other weekend?
It was originally supposed to be every weekend. But since the court order, he had missed about 4 weekends. So
Okay, so what safety concerns do you
I
have?
don't know how. So for this previous weekend, Zakai Payne, half of his hand had got second-degree burn, and nobody had took him to the hospital. They just dropped him off and didn't even let me know anything. Just let me see for myself.
I object to that.
The mother describes a serious burn on one child's hand, claiming no hospital visit and no warning. The father objects, but not legally. The judge shuts that down immediately. This exchange is sharp, uncomfortable, and revealing. It shows how quickly credibility can be lost when objections aren't grounded in law. The court isn't deciding guilt here. It's deciding who understands process, accountability, and how to properly raise concerns in court.
What's your legal objection? Mr. Jones, unmute yourself. You have to have
Yes,
a legal objection. You just can't say I don't agree. So, do you have a legal objection?
yes, sir. I tried to communicate that when I dropped them
What's
off.
the legal objection?
A legal objection is saying that that's not true. I've been grabbing the
Okay,
kids.
that's overruled. That's not a legal objection. Okay, go ahead, Ms. Nutt.
Okay, so Miss Payne, has there been any other instances where you had safety concerns for the children being in Mr. Jones's possession?
Prior to that, it was like scratches on their neck. I know that he has dogs, so I didn't really make a big deal of that. But when it comes to like burns, big problems like that, and accidents that I'm not getting information about or anything that's going on, I'm figuring out for myself, and then I have to deal with the consequences. I have to take off work and take him to the hospital.
Okay, so Miss Payne, how old are the children?
1 year old. They just turned one in August.
Okay, and they're twins, correct?
Yes.
Okay. Okay, I'll pass the witness.
Okay. I don't know if y'all are listening to each other today because what I'm hearing from Mr. Jones is saying Miss Payne doesn't listen to me. She doesn't communicate with me. She doesn't give me a lot of information. Miss Payne, I hear you saying Mr. Jones doesn't give me a lot of information. He doesn't listen to me. We don't have good communication. I don't know if you haven't heard it, but that's what I'm hearing. So it takes a two-way street. You both want information. I agree. You both should have it. You both should be able to communicate. I can't make you. I can't make you. But it's a two-way street. You need to ask yourself when you leave here today, am I doing everything from my side to communicate and be open? And if you can't answer that, uh, I mean, right now, I would say your answer would be no, from what I'm hearing from both of you, because the other person's not happy about the information they're receiving. So you should walk away thinking, okay, I need to do more. I need to step up my communication a lot more than that. I understand kids get hurt. It doesn't necessarily mean it's a fault of somebody or the other. Um, it's obviously we don't want them to get hurt. But those are things that we should be able to talk with each other about. If a child has a fever, we should be able to tell the parent, hey, someone has a fever, but I gave them some Tylenol. They're doing better now. They're sleeping. Doesn't mean you have to go run and go take the child to the hospital. Doesn't mean the other parent's going to come and take the child away. Just communicate. If you have a burn or something like that, say, hey, got a burn. I'm treating it. Looks okay. I don't think you need to go to the hospital. Pretty easy. Child falls down on a bike, skins their knee.
The judge lays it out plainly. Both parents are saying the exact same thing about each other. Lack of communication, frustration, and distrust go both ways. Injuries happen, especially with toddlers, but silence makes everything worse. This lecture isn't about punishment. It's about co-parenting survival. The judge explains, step by step, how simple communication could prevent conflict, panic, and repeated court appearances.
So and so fell down on their bike today. I've cleaned it up, put some medicine on it. Hurts a little bit. Gonna move on with our day. It doesn't take a lot to send it. I mean, even today with text and email, you don't even have to have a verbal conversation. You don't have to panic on the other side either when like, oh my gosh, something happened, because these are normal things that are going to happen. Especially with 1 year olds, they fall down all the time. Now, if it's something that's out of the normal, then I understand. But if it's the normal stuff, I mean, just communicate with each other. I hear you both saying and complaining about the exact same thing. So it tells me that both of you are not doing a good enough job yet. So both of you need to improve on that. Um, I don't really sure about all your other complaints. I mean, we're gonna make the temporary order final order. You couldn't change the child's name until I did a final order, which is being signed today. So that's not something that you could have done anyway. But that's something that Mr. Jones you can do now after you get a copy of this order. If you don't believe Miss Payne wants to do it, you can do that. You're the father. You can also go visit the Social Security office and get an insurance card. Um, those are things that y'all have the power to do, but you should make things easier. Don't make it harder on each other. And then nobody wants to sit in the Social Security office for hours when you can get the information in a minute or two. I mean, that's nothing difficult there. Um, You know, y'all got to work on communication. That's what it comes down to. All right. The visitation that I ordered is not what you said, Miss Payne. The visitation I ordered was visitation every other weekend. Now if
Every,
y'all want to agree to something different than that, that's up to y'all. If y'all want to do more, I'm okay with that. You want to do less, I'm okay with that. That's what, if y'all want to agree to something different, that's fine. I'm
okay.
not going to make Mr. Jones, please don't interrupt me. I'm not going to make Mr. Jones visit if he can't or doesn't want to visit. I'm not going to make him visit. The only thing that's ordered to be done is the every other weekend. Um, some people don't visit. That's just unfortunately that's the case. But I don't hear that that's Mr. Jones. So if he missed a few weekends in there, that's probably weekends he probably wasn't going to do anyway if we did it every other weekend anyway. So I don't know what the complaint about that is either there. So again, y'all need to have a conversation with each other. Maybe go drink some coffee somewhere, go have some Starbucks or something and have a conversation. A decent civil conversation about how y'all going to do this because y'all going to be together even though you're not together for a long, long time with these twins. And these twins are going to have a lot of issues throughout the time. And I know y'all may not be dating each other anymore and all that, but y'all going to have to coexist with each other as parents and communicate a lot better than you are. All right, so they'll submit me a final order. This is pretty much going to be the same as the last one we did in August, and that'll finalize your case. We won't have any more court dates. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
The court finalizes the temporary order, clears up visitation misunderstandings, and reminds both parents they'll be tied together for years, whether they like it or not. No more court dates, no more excuses, just responsibility and cooperation. This case ends not with fireworks, but with a warning. Grow up, communicate, and put the kids first. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.